Thank you very much. Allow me to bid you a warm welcome on my behalf as well. Before I touch upon the presentation of the adopted Act on Social Entrepreneurship, allow me to tell you at the outset that this is an act initiated by deputies. You probably know that the majority of acts in the Slovenian parliament are presented by the Slovenian government. However, in this case, the initiative was put forward by deputies. I was the second which signed its name on this initiative. I regret the fact that Dr. Andrea Črnak-Meblič, who was the first signed and initiated this document, is not present here today. She was the leading force behind the adoption of the Act. She also coordinated the group of deputies in the Parliament who promoted the adoption of the Act, and I believe that she can be credited. Then, assistance was also provided to us by a group of experts. I would like to thank this opportunity to thank Zdenka Kovač, Master of Science. And they gave us appropriate expertise, forwarded requisite information in order to transform them and translate them into the Social Entrepreneurship Act. More than 1 year, we had to consult and coordinate affairs within the Slovenian Parliament. And it gives me great pleasure that on the 18th of March, i.e. last month, the National Assembly passed this act as well. It needs to be said that this was endorsed and approved by a consensus, which in fact is something unusual because all 70 deputies present approved it. We have many referendum, and let me tell you that I'm not afraid that this act will be tested and trialed at the referendum. Even if this was the case, I believe that it would be endorsed and it would win a landslide victory. As for the Act on Social Entrepreneurship, it was our objective that we need to create systemic conditions in order to boost social entrepreneurship in the Republic of Slovenia. Therefore, the Act defines which entities, in fact, can operate as social companies, then which criteria they need to meet, then what activities should these companies be involved in, and that these activities benefit the society as a whole, and lastly, which groups at the labour market need to be employed by these companies in order to have a public interest recognized. As for the Act, it defines the concept of social entrepreneurship in line with standards and criteria as devised by the European Commission. We took a decision when preparing this Act that we would have the so-called open model of social companies, i.e., we didn't focus merely on one type of legal entity which might be involved in social entrepreneurship, but we want to, in fact, bring closer the concept of social entrepreneurship to the already existing NGOs and legal entities. This is the reason why we opted for this model. It enables the transformation of different legal entities into social companies, so that society, institution or institute, cooperatives have a possibility that in line with this Act, they in fact transform their companies, they register and become social companies. The Act also involves and identifies objectives and criteria for social companies, then criteria and activities are listed and they are envisaged by the Act. In line with this Act, social entrepreneurship will be implemented. And then the so-called vulnerable groups, the labour market, are also identified, and it is expected that social companies will recruit these individuals. They, in fact, will be reintegrated and re-employed at the labour market. They will be able to find jobs. So, in fact, in the past, they were passive recipients of social aid, but now, in the future, they will be reactivated, they will become active at the labour market, and they will find employment. When it comes to social entrepreneurship, the following legal entities can be involved. Their basic purpose is not profit-driven activity and distribution of profit. They can be involved in manufacturing, sales, and providing services at a market, which are defined as benefiting the society within the Act. And this is the basic distinction. So we have the so-called Type 1 social companies, those companies which will be involved in social entrepreneurship activities as defined in the Act and as benefiting the society. And then we also have Type B social companies. It is not identified that they should follow these activities as defined in the Act, but they benefit the society in such a way if they give job to vulnerable groups who have difficulties in finding job at the labor market. Then when it comes to social companies, the following rules or principles are or have to be complied with. We have a private initiative behind the establishment, then non-profit making character, also a social characteristic, then voluntary activities. They are market-oriented. Then voluntary work is also a very important component. Equality of their membership is highlighted. The employees are involved in the management, and when it comes to their business operations, it should be as transparent as possible. The Act also introduces very detailed provisions when it comes to Type A social companies. We listed a host of activities which are to be pursued by social companies. We really worked hard in order to expand the scope of possible activities. It was also our desire that in the initial stages we should promote the development of social entrepreneurship, so we should give the food for thought in a way to instill an entrepreneurial spirit, so social care, family care, protection of the handicapped, science, research, education, nurturing, promotion of health, social integration, then organic farming, preservation of nature, environment planning, promoting renewable resources of energy and green economy, promoting the so-called social tourism, then fair trade, when it comes to promoting and developing local communities, as well as providing support services for social companies as such. A couple of words about how the Act, in fact, envisages for a certain company to be given the status of a social company. This can be a non-profit legal entity which can permanently be involved in social entrepreneurship activities, and it should, in the first year of its activity, recruit at least one worker and a minimum of 2 workers in its following years of operation. This goes for the Type A social company. And when it comes to the Type B social company, it should employ those individuals with lower employability chances, and this employment should be permanent, and at least 1/3 of its workforce should be recruited in such a way. Then the status of social companies can be maintained if, in line with the deadline stipulated in the Act, this entity can demonstrate that social entrepreneurship activities were pursued and that this company, in fact, has a number of recruited individuals in line with the Type A or in line with the Type B workforce. When it comes to Type A, in its first year of activity, the company should generate at least a minimum of 40% of its income from social entrepreneurship activities. And in the following years, and in further years of its operation, this margin is set at 50%. Also, the Act stipulates that social entrepreneurship principles should be obeyed. When it comes to non-profit making activity of the company, the Act says that income and surplus income from social entrepreneurship activities should be earmarked for those activities which are deemed social. When it comes to certain limitations put forward by other sectoral acts, it was impossible to stipulate that all profits of legal entities active in social entrepreneurship should be reinvested 100%. There are certain exceptions, however, which are registered in line with the Companies Act. And in this case, there is in fact a possibility that if profits are distributed, it is limited to 20%. The intention of proponents and further development is that when social companies gain ground, this condition should be in fact transformed, so that we would lower this to 0%, and all social companies operating in the Slovenian market should in fact reinvest its profits in their basic activity 100%. A lot of attention has been paid to so-called indirect distribution of profits, so that creative accounting should not be employed. In this way, we banned any disbursement of bonuses to the management or employees. We also limited the distribution of income and wages. A ceiling is put at 30% for starting wage within an individual wage bracket. This also goes for travel costs. The reimbursement is also limited to certain amounts as stipulated by various acts and bylaws. At the end, let me also talk about the support environment. This is also defined within the Act. The Ministry of Family, Labour and Social Affairs is the relevant ministry. Mrs. Košir will talk about the details. She will address all the steps involving the support environment. The Act also envisages that we will have an interministerial coordination of social policies and models. Therefore, the Council for Social Entrepreneurship will be formed within the government. In addition to relevant ministries, we will also give an opportunity to NGOs. The responsible ministry, as I said, is the Ministry of Family, Labour and Social Affairs. The Act also envisages that the development strategy for social entrepreneurship will be passed. We will have very concrete steps. We will define all the mechanisms, including financing mechanisms, leading to the support environment and further development of social entrepreneurship. Thank you very much for giving me the floor. I hope that this conference today and tomorrow will